along with his attorney of record, Ronald Wood. Sydney Simon appears separately from her attorney of record, Lauren Schuler. This matter comes before the court at this time for further proceedings. Counsel, this court had conducted a trial in this case, made rulings and orders which should be journalized by now. As far as I know, the court does not have a journal entry of judgment and decree of divorce submitted as of this point. I also note that Mr. Wood has moved to withdraw his counsel for the petitioner in this case, which has actually been objected to by the opposing party. So I'm going to start with Ms. Schuler and ask her, where are we at on this case?
Thank you, Your Honor. So did you receive my exhibits?
I did.
Okay. So I did draft a journal entry. The proposed journal entry is Exhibit A. I did supply the email that I sent the journal entry, showing that I sent the journal entry to counsel Mr. Wood. I sent that on Tuesday, May 13th. As you stated, we did have trial on May 7th. I did supply as well, which is reflected in the court filing, Exhibit C, which is Mr. Wood's objections. If you look at the objections, Your Honor, unfortunately, a majority of them are not actual legal objections. They are essentially requests to change your ruling. And I can go into further detail, but I would argue 80% of them are just requests to change your ruling. They're not actual legal objections. And I think that's where we're at a standstill. I was waiting on this hearing.
What about the other 20%?
I did make
corrections that are appropriate?
I did make them.
Okay.
So specifically objection 1, 3, 7, 17, and partially 14 were all made. Missing a comma or referencing specifically the parties for joint legal custody. I did make those. But outside of that, the others are requests to modify your ruling. So I was waiting on this hearing to file a motion to settle the journal entry. So that's where we're at on the journal entry. I will wait to go.
Before we dive into the courtroom audio, let's talk about what's really happening here, because this is one of those cases where the law is simple, but the emotions are explosive. What you're about to watch is a divorce case that has already gone to trial, already been ruled on, and should honestly be wrapping up. But instead, it's spiraling because one party refuses to accept the outcome that we've got a husband who believes firing his attorney and representing himself is going to magically change the judge's mind. We've got a lawyer with nearly half a century of experience trying to explain procedural reality. And we've got a judge who is very calmly, very methodically shutting down every attempt to relitigate settled issues.
Before allowing you to withdraw. I do understand the nature of your motion in this case, but I do note that on behalf of your client, you filed certain objections back on June 3 to the wording of the proposed journal entry of judgment and decree of divorce. Some of these cosmetic changes have been made, apparently. I understand that your client may not be 100% in agreement with the court's ultimate rulings in the case, but what this journal entry is intended to do is to simply document what the court did rule upon. So what's the problem here, Mr. Wood?
Well, Your Honor, I received from my client approximately 4 pages of changes that he wanted to make in the journal entry. I took those at the best I could and made those objections known to the court the best I could that would not be considered frivolous or completely not allowed in this type of a review of the journal entry. So I did what I could. And then once I did that, then I received wording from my client that he was did not approve of what I have objected to and wanted to know why I didn't use everything that he'd given to me as objections in the journal entry. So I did what I could to pare it down. What really concerned me, though, also is that I filed that on June 3rd, but on his what he had sent back to me, objecting to what I'd sent, he'd start sending copies of that to the disciplinary administrator. And so that concerned me whenever the disciplinary administrator gets involved and indicates that, you know, she didn't want to be involved with that. So I understand the court's position on withdrawing, but I had to put forth the objections that my client in some manner objected to with the understanding that I think some of his objections really would be more of a motions for rehearing or motion for modification. And that's a little bit of a problem when people are using the internet or whatever they're using to come up with attempting to practice law. And so they don't understand the distinctions between those and the objections to the journal entry. You know, the journal entry is supposed to recite what this court had ordered. And it's not to be the objections to what the court had or whether you agreed or disagreed with what the court ordered. The journal entry is to reflect what the judge ordered. And whenever I get something saying, no, these are all the objections I have to the journal entry, and I'm sending these copies of all this to a disciplinary administrator.
This is where the entire conflict crystallizes. What opposing counsel is explaining, very carefully, is the difference between a legal objection and a personal disagreement ***. A journal entry isn't an opportunity to renegotiate outcomes. It's not a suggestion. It's a written reflection of what the judge already ordered after trial. So when she says, 80% of these aren't real objections, that's not rhetoric, that's procedural fact. Courts allow corrections for clarity, typos, ambiguity, or accuracy. What they do not allow is quietly rewriting a ruling you don't like under the guise of editing. And notice something important, she did make legitimate corrections. That tells you this isn't obstruction, it's precision. The problem is that the remaining objections are
doing a job for him, then I just figured I had to withdraw, Your Honor.
All right. Ms. Schooler, I'm going to go back to you for a moment. I trust that there's been some personal communication between you and Mr. Wood in an attempt to try to reconcile differences on the wording of the journal entry, perhaps a recent phone conversation or email chain or something?
I did call Mr. Wood. I did let him know I was going to have to object because we were still in the process of working out this journal entry. You did order for some documentation to be provided to me by petitioner in regards to picking a vehicle. So I said, hey, get me that. We did not go into the journal entry as much. I did let him know, hey, I made some of the cosmetic corrections, but you know, your objections are, or your client's objections are, again, more so for reconsideration, and I'm not going to make those changes. And that was after the our Exhibit D, the email including me and Mr. Wood with the disciplinary administrator, where Mr. Presbeal says he is going to file an ethics complaint against me. So not as much as I'm sure the court would prefer, but obviously with this email coming out, I believe Mr. Wood was trying to be as cautious as he could due to the situation.
All right. So the first issue before the court is settlement of the wording of the journal entry in this case. And in doing so, I'm going to try to systematically go through here and determine, is there a legitimate objection to the wording used by Ms. Schooler in what I see as, and I want to make sure everyone's on the same page as to what I'm referring to. In my exhibit notebook, it's Exhibit A, which is what I believe is Ms. Schooler's most recent attempt to draft an appropriate journal entry of judgment and decree of divorce. Is that correct?
Yes, it is, Your Honor. All
right. Obviously, the comma in number 1 has been resolved. Petitioner objects to the court's finding, and the petitioner will not respect the bond of the respondent. Oh, to the extent, apparently, that the petitioner will not respect the bond of the respondent in this matter. If that's consistent with a ruling from the bench, and I think it is, then that's not objectionable. Okay.
May I make a statement?
Mr. Presbeal?
Yes, sir.
So-
That's me.
What's your statement?
My concern here is several things in the journal entry are not written how the court ordered. I have recently filed for a transcript request for the judgment in this case. I've paid for that and I have a receipt for it. And a lot of the wording affects the legality of the court's judgment. And when it comes to getting involved with disciplinary administer, I done that because Mr. Woods failed to address our son getting bit by a dog while in his mother's care, failed to address Sydney not showing up for
Okay, we're
exchanges
getting
of
off the
court
path
order
here.
twice.
We're
No,
getting,
sir, we're not.
okay. All right, regarding number 2, the court will overrule any objection to this finding. Mr. Simon's actions in, as I recall, taking possession of the child at a bus stop, that alone gives this court pause and some reason to make a finding that the court has concern that Mr. Perez-Beal will not respect the bond of this child with his mother.
That was during my
And there are other
parenting
reasons.
time.
However, the court finds that the objection is overruled as to number 2. Number 3 apparently has been corrected. As the court recalls, there was a protection from abuse case previously between these parties. The court finds that even though Mr. Perez-Beal may deny that there was ever any abuse by him, court does find that that's an appropriate finding for the court to make. And the court will
Point of
overrule the
order.
objection to number 4. The court also finds that there has been difficulty between these parties based on the evidence to effectively communicate regarding setting a parenting plan or deciding many important matters concerning this child. So the court does
I'm
find that there's
submitting all of
evidence
our
in the
text
record.
messages.
All right, if you interrupt one more time, Mr. Perez-Beal, we're going to mute you or take you out of the meeting completely.
Yes, sir.
This moment matters more than it might seem. When an attorney asks to withdraw, it's rarely impulsive, it's usually the last step after communication breaks down completely. But the judge immediately pumps the brakes, and that tells you everything you need to know. The court wants the journal entry settled first because the ruling needs to be preserved accurately before representation changes. Judges care deeply about clean records. They don't want chaos, confusion, or later claims of misrepresentation. And they definitely don't want a self-represented litigant trying to rewrite history mid-process. This also signals that the judge already understands the underlying issue. The client doesn't disagree with the wording, he disagrees with the outcome. And the court is making it crystal.
All right, so number 13.
A lot
West
of the
Schools,
objections-
why is that a problem?
A lot of the objections he made are not what I requested, and I'm getting ready to submit that,
All right.
what I have requested to him.
Okay, I think the children do attend West Elk schools, correct?
They
Yes,
do.
sir.
Okay, so what's improper about 13? I
He
don't
has
see any
manipulated
problem
my
there.
objection request.
Okay. I don't think we need to put the USD number in there. I think the term West Elk schools is specific enough. I'll overrule any objection to 13. Number 7 apparently has been corrected, Ms. Schooler.
Yes, it has been.
With the orders and rulings of the court as it currently reads. Objection 8. Is there some dispute about the amount of child support to be entered into the record here?
Yes,
Yes.
sir. There's been 3 child support worksheets entered on this without a chance for me to do taxes and submit financial records. And her most recent one states it was filed in, I believe, June 13th
Okay, well,
or May 13th.
okay, wait a minute. Let's back up. Mr. Wood indicated in his objection that I ruled from the bench that I was specifically adopting a particular child support worksheet that called for an amount of $1,383. So why wouldn't that be appropriate, Ms. Schooler?
Your Honor, because you did not adopt a specific worksheet, we imputed Mr. Presbeel's income at 58,000, I think $230. I might be off on the last few dollars, but he was
58,320.
imputed. Correct. And I had to make the tax adjustments, so there was no actual worksheet adopted because I had to make a change. But he was imputed by you, or his income was ruled upon that it needed to be imputed. So the February 12th worksheet does not have the imputed income because we were never provided that information.
There was never no paperwork filed to omit the previous and lay out a lot of things that have gone on here that I believe Miss Schooler and Mr. Woods are discussing and kind of having backroom conversations. Mr. Woods' motion to withdraw on our inability to see eye to eye on this is false. I use a phone recorder, and Mr. Woods previously told me, I believe it was the 10th, that he demanded $7,000, and if I didn't pay, he was gonna withdraw.
All right.
So
Okay,
extortion.
I'm really just focusing on the child support worksheet, one issue at a time. I don't see your proposed worksheet, which calls for that amount. Ms. Schooler, it's not, it doesn't appear to be an attachment to your journal entry.
What about the one, the respondent
Okay,
file?
Mr. Presbeil, be quiet for a moment.
December 20th.
I'm addressing Ms. Schooler. The worksheet that you're depending upon to justify your amount in your proposed.
This is one of the most honest moments you'll ever hear from an attorney on the record. Mr. Wood isn't venting, he's explaining the ethical and professional line he refused to cross. His client sent him 4 pages of demands, and he filtered out the ones that were frivolous or procedurally improper. That's not betrayal. That's competence, but once the client starts sending complaints to the disciplinary administrator, everything changes. That's no longer a disagreement, that's an accusation. And once accusations enter the room, trust is gone.